Those of you who have watched my series on federal jurisdiction, you can find it somewhere on the channel here, I'm sure. You would all know that there is a removal statute that allows somebody who is sued in state court to remove the case to federal court if it involves a question of federal jurisdiction. For example, it invokes a federal statute for relief, or in the alternative, if it involves citizens of different states, what's called diversity jurisdiction. In that situation, the defendant files a notice of removal and the case gets removed to federal court. But there's a different removal statute that doesn't get a lot of talk, and we're going to discuss that one today. Here's what we're talking about today. Several weeks ago, you may have seen in the news there were some comments made by people in Oregon, I believe, and California about the ICE officers being rough with some of the protesters and that they didn't feel that some of the tactics and the actions were appropriate. I take no position on that. I pointed out because the state officials in those two states made vague threats about arresting and prosecuting these ICE officers for that conduct. And that would involve a big problem because in doing so, they would run afoul of the federal removal statute that governs prosecutions of federal employees acting within the scope of their authority. And that is this statute. This is 28 United States Code, Section 1442, Federal Officers or Agencies Sued or Prosecuted. A civil action or criminal prosecution that is commenced in a state court and that is against or directed to any of the following may be removed by them to the District Court of the United States for the district and division embracing the place wherein it is pending. 1. The United States or any agency thereof, or any officer or any person acting under that officer of the United States or of any agency thereof in an official or individual capacity for or relating to any act under the color of such office or on account of any right, title, or authority claimed under any act of Congress for the apprehension or punishment of criminals or the collection of the revenue. Now, as you might imagine, there are not a lot of cases that are interpreting that particular statute. And that's because I think most people understand that the Supremacy Clause governs the interaction between states and the federal government. So if you have a federal officer, for example, going and arresting someone in Kansas City, Missouri, and taking him into the federal pokey, and during that arrest, somebody in Kansas City claims that it was an unlawful or illegal arrest and that the officer should be charged with false imprisonment. Well, again, he's acting within the course and scope of his duties, and so the Supremacy Clause would trump the state law in that situation. But that doesn't mean that the case in the state court would go away. So the way that you prevent that from becoming a problem for these officers is through this federal removal statute that grants them the right to take a case that is filed against them, either civil or criminal, into the federal courts. And of course, actions against the federal government are routinely filed in the federal courts because that's where jurisdiction lies. But actions against individual federal employees sometimes get filed in state court and wind up getting removed into federal court. Ordinarily, that would be just something I think that would not be of great interest to most people, but a certain notable person has recently caused an opinion to be written that deals with this federal removal statute, and his name is Donald J. Trump. And so I want to point this out before I get started that I am making no determination one way or the other whether Trump's prosecution was right or wrong. I'm making no determination as to whether or not this ruling is good or bad, and I will attempt to explain this ruling in the most unbiased way that I can possibly explain it. With that understanding, here we go. This is the people of the state of New York versus Donald J. Trump, and it's an appeal to the Second Circuit. In March 2023, the grand jury in New York indicted President Trump on 34 counts of falsifying business records, and he was convicted. And before that, he sought to remove the criminal case against him to federal court, relying on the federal officer removal statute, which is 28 U.S.C. Section 1442A1, the one we just discussed. The district court remanded the case after determining that it did not fall within the scope of the statute, and following a state court jury trial, Trump was convicted on all counts. After Trump's conviction, but prior to sentencing, the United States Supreme Court issued its presidential immunity decision in Trump versus the United States. Trump thereafter sought leave to file a second untimely notice of removal pursuant to Section 1442A1 and 28 U.S.C. Section 1455B, which establishes the procedure for removal of criminal prosecutions and requires that the defendant show good cause for an order granting leave to file late notice. Trump argued that the Supreme Court's intervening decision rendered the state prosecution one relating to his official acts as president, and it was now removable and established good cause for his untimely filing. The district court denied that leave, and among other things, it concluded that there was not a good cause. It says here that the Second Circuit cannot be confident that in doing so, the district court adequately considered issues relevant to good cause so as to enable meaningful appellate review. Now, what does that mean? It means that if the district court had adequately laid out all of the facts it relied on and the legal conclusions that it reached, then this court could make a determination as to whether it was right or whether it was wrong in denying leave to grant removal. But unfortunately, the district court did not do that. In fact, it was more of a summary order, and it didn't really discuss to any length the issues of good cause. So it says, for example, a district court did not consider whether certain evidence admitted during the state court trial relates to immunized official acts, or if so, whether evidentiary immunity transformed the state's case into one that relates to acts under the color of presidency. Nor did the district court consider whether any notice of removal of a criminal prosecution must be filed before trial, even if new grounds for removal arise during or after trial. We therefore vacate the district court's order denying Trump's motion for leave to file a second notice of removal and remand for reconsideration of the motion consistent with this opinion. So let's be clear here. What this means is that the district court is going to have to take a fresh look at the second, or I should say, the motion for leave to file a second notice of removal and either grant it or deny it. And in granting or denying it, it's going to have to lay out the answer to a lot of questions that the Second Circuit asks in this particular opinion. And we don't need to go into all of those, but let's look at a few. Here's how they start. The federal officer removal statute permits a defendant in a state criminal prosecution to remove the action to federal court if it's for or relating to any act under color of federal office, and the defendant raises a colorable federal defense. The statute's basic purpose is to protect the federal government from the interference with its operations that would ensue were a state able, for example, to arrest and bring to trial in a state court for an alleged offense against the law of the state officers and agents of the federal government that were acting within the scope of their authority. That's Watson versus Philip Morris, which is a 2007 Supreme Court case. But there are rules the defendant must follow to get this statute in application and remove it to the federal courts. Among them is the requirement that he file it not later than 30 days after the arraignment in state court or at any time before trial, whichever is earlier. On a showing that good cause exists for doing so, a federal court can enter an order granting the defendant leave to file the notice at a later time. Because the district court does not appear to have considered important issues relevant to the removability of the underlying state prosecution, we vacate the district court's order and remand for consideration of the motion consistent with this opinion. So it goes through the fact that he was indicted and that he was basically had directed his personal lawyer to pay $130,000 to an adult film star to keep her from publicly revealing an encounter with Trump. Following a nearly 7-week trial, the jury convicted him on July 1, 2024. After the conviction, but prior to sentencing, the Supreme Court issued its presidential immunity decision, and he said that essentially the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authorities. Separation of powers principles, the court explained, necessitate at least a presumptive immunity from criminal prosecution for the president's acts within the outer perimeter of his official responsibility. Most relevant here, the Supreme Court also held that even when an indictment alleges only unofficial conduct, prosecutors may not introduce evidence of the president's immune conduct. Now, immunity creates all kinds of problems for courts. You may recall recently the Maya Kowalski case. The whole reason that case was vacated and remanded back to the trial court was because it screwed up the analysis of the immunity provisions. And the federal immunity provisions are different and structured in a different way from the Kowalski issue, but the principle remains the same. If you screw up the immunity issue, then nothing that you get in the state court case is going to hold. So, in light of that opinion, he filed a second untimely notice of removal, and among other things, he argued that the state's prosecution was related to his official acts. And the district court denied leave to file the notice of removal, principally on the ground that he failed to show good cause. Trump now appeals that order denying his motion for removal. According to the indictment and the evidence presented at trial, Trump orchestrated a scheme with others to influence the 2016 presidential election by identifying and purchasing negative information about him to suppress its publication and benefit his electoral prospects. And it involves Michael Cohen, his personal lawyer, and sort of camouflaging payments that were made to him as legal services when they were actually just reimbursement for what amounted to a hush money payment. The Trump Organization maintained business records of those checks, and instead, according to the indictment, Trump caused his entity's business records to be falsified, and it violated New York law. A month later, Trump filed a motion to remove the case to federal court. The removal notice asserted that the indictment charges President Trump for conduct committed while he was President of the United States that was within the color of his office, and charges involve alleged federal and state election law violations that have a federal preemption defense. In other words, essentially what the Trump team here was arguing was, you can't prosecute me in state court for violations of federal election law, which is essentially what Mr. Bragg attempted to do. So the state moved to remand the case to state court. After conducting a hearing, the district court concluded that Trump had failed to meet its burden of establishing removal jurisdiction and didn't grant the removal. The district court explained that hush money paid to an adult film star is not related to the president's official acts. Well, I would hope not. And it doesn't reflect in any way on the color of the president's official duties. Again, I would hope not. The court accordingly granted the state's motion to remand. Trump appealed the decision, but for reasons that are not clear on the record, dismissed his appeal in 2023. And if there's anything that comes back to haunt him, it will be that. On July 1, before Trump's scheduled sentencing, the Supreme Court issued its decision. And one of the things that was important is whether or not the intended effect of immunity would be defeated if a president's official acts could be scrutinized to help secure his conviction. So, evidence of the president's immune conduct must be inadmissible even when the indictment alleges only unofficial conduct. So, the question that naturally arises, according to the Second Circuit, in connection with the good cause inquiry, is whether the state's prosecution of Trump was ever one for or relating to his official acts as president. In urging that we answer yes to that question, Trump claims that the state improperly relied at trial on at least three categories of official acts evidence later precluded by the Supreme Court's decision. First is the testimony that President Trump allegedly told Cohen that an FEC inquiry would be taken care of by then Attorney General Jeff Sessions. Second is the testimony from Hope Hicks concerning private conversations with President Trump regarding matters of public concern relating to Cohen and his activities, which occurred in the Oval Office while Hicks served as White House Communications Director. In other words, they brought into state court conversations between Hicks and Trump that occurred in the Oval Office while Trump was serving as president. And third is the evidence of official statements by President Trump in 2018 on Twitter regarding matters of public concern. By offering the official acts evidence, Trump contends the state made their case one that related to the acts under color of the presidency. Now, whether that's right or whether that's wrong, nobody knows, because this district court did not do an adequate job of analyzing the evidence and analyzing the actions of the president. So the Second Circuit instructs the district court to do some additional analyses. First, it notes that the color of office test requires a showing of a causal connection between the charged conduct and the asserted official authority. But that was amended in 2011, and we recognize that it was intended to broaden the universe of acts that enable federal officers to remove to federal court. Without guidance from the Supreme Court and about the effect of the 2011 amendment, the sister circuits have taken different approaches on the issue. Whether Trump constructed a new road for removal under 1442 turns initially on whether any of the three categories of challenged evidence relates to immunized official acts. If so, there remains the question of whether admitting that evidence transformed the state's case against Trump into one that relates to acts taken under color of the presidency within the meaning of the amended removal statute. So, that's really at the heart of this. The rest of everything else is kind of noise in this case, but that's really the heart of this case. And if it is properly analyzed, then we'll have an answer to it. It could be that it doesn't transform it. It could be that it's an error and that evidence should be stricken from the record, and then whether or not there was sufficient evidence for a conviction should be scrutinized with that evidence removed from the record. Or it could be that no additional action is necessary, and the conviction would stand and the removal would be essentially denied. But the question is not what the Second Circuit thinks at this point, but what the analysis will be by the district court. In its denial of leave to file a second removal notice, however, the district court did not address whether Trump acted diligently. In fact, the district court did not grapple with any of the central issues we've identified above, explaining only that nothing in the Supreme Court's opinion affects the previous conclusion that hush money payments were private unofficial acts outside the bounds of executive authority. The court bypassed what we consider to be important issues bearing on the ultimate issue of good cause. Whereas here the district court failed to consider relevant factors, we cannot determine whether the court abused its discretion and are therefore constrained to remand the case for further consideration. So that's what's going to happen. Now, quite clearly here, one of two things could happen. The district court could analyze this in accord with the Second Circuit's opinion, which has given them a number of different questions to answer, and it could conclude that good cause was not shown and removal is not proper. Or it could conclude that good cause was shown, but that in spite of that, there's not a federal defense, or there is not a reason then to remove the statute or remove the action to federal court. Or it could decide that maybe it should have been removed and could remove it, but now you've got the issue of what happens after in terms of the case having already been adjudicated. So there is a huge tangle of string here. If you've ever tried to untangle Christmas lights at this time of year, then you have a good approximation of what it's going to be like for the appellate courts and for the district court to kind of untangle this mess so that you have a legitimate answer under both state law and federal law. And nobody knows at this point what that's going to be. But we do know one thing, and that is no matter what that court decides, whoever is aggrieved by that decision, whether it's the state of New York or whether it's President Trump, somebody's going to appeal. It's going to go to the Second Circuit, and from there it will probably go to the Supreme Court. And one way or another, 3 or 4 years from now, we'll have an answer on that. And that's exactly the way the law was intended to work. And that's also the reason why the Supreme Court didn't get in there and stay the sentencing when he asked him to do that in January of 2025, because those issues can wind their way through the appellate courts in New York. And consider this: if, in winding its way through the appellate courts in New York, the court in New York decides, hey, this was an improper prosecution and the legal theory is faulty, and as a result, we're going to vacate and remand with instructions to dismiss the case, then it will become moot in both the state and the federal venues. There won't be any purpose to continuing on with this removal discussion because it will not be capable of repetition and avoiding review. In other words, there will be a moot issue, and nothing the Supreme Court or the appellate courts can do would change that mootness. And actually, that would probably be the best option or the best outcome for President Trump, because if you wind up removing this to federal court, then you don't get to import the trial testimony into federal court and just have a do-over on the record. There would have to be a federal trial. And of course, you couldn't have that while Trump was president because he can't go spend his days in court while he's in the Oval Office. So, again, huge mess in terms of how this is all going to shake out. We're just going to have to wait for it. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee, anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.